Good afternoon or good morning, everybody. Congratulations, Virginia, on making it to the top 12 in the We the People competition. We're going to introduce ourselves and ask you to introduce yourselves and your teacher. And then I'll read the question. We're going to ask you this morning about question 1. And then we'll hear your opening statement and have a chance to ask you questions and conclude with some feedback. My name is Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado.
I'm Lindsay Draper, retired from the juvenile court bench here in Milwaukee County, Wisconsin.
Hi, I'm Thomas Maggie. I'm in the history department at the University of Louisville and with the law school here at the University of Louisville.
Would you like to introduce yourselves and your teacher for us, please?
Hello, I'm Ethan Ringer.
Hi, I'm Sam Fiddler.
Hi, I'm John Staley, and our coach is Mr. Sam Olmschneider.
Welcome. Let me read the question now. What were the major disagreements among the 55 delegates during the Constitutional Convention in Philadelphia, and how were they resolved? What issues, if any, were not resolved, and what were the consequences? What changes, if any, should be made to the Constitution? You may begin.
In a letter to Gouverneur Morris discussing issues which might be important at the convention, George Washington claimed, "There is not a man living who wishes more sincerely than I do to see the abolition of slavery." James Madison refused to mention it directly in the document because he thought it wrong to admit in the Constitution that there could be property in men. Although many delegates to the convention viewed slavery as malign, its economic entrenchment, coupled with implications for representation, made resolution at the convention impossible.
Delegates focused most of their efforts on representation in the national legislature, at least 33 of the 116 days. Despite disagreement between proportional representation offered by the Virginia plan and state equality proposed by the New Jersey plan in response, the convention truly resolved this issue via the Great Compromise by integrating both systems. In contrast, the constitutional compromises on slavery, notably the Slave Trade Clause, the Fugitive Slave Clause, and the Three-Fifths Compromise, would only serve as delaying mechanisms.
This delay was permissible to the convention's attendees because they viewed slavery as subordinate to the goal of national unity. However, this postponement would result in decades of political tumult and human suffering. Regional divisions became abundantly clear during the debates over the Missouri Compromise. Northern and Southern politicians tried to compromise on slavery in the 1850s, but failed. For these reasons, the decision by the convention to postpone decisions about slavery and empower states with slave interests had the most destructive influence.
Another highly contested issue at the Philadelphia Convention was the distribution of power between federal and state governments. In his Virginia plan, Madison proposed mixing elements of confederal and unitary systems. His bicameral legislature would include one house elected by the people and one indirectly appointed by the states. He argued against confederacy, but supposed that a single unitary republic would be unattainable for so large a nation, so he proposed a compound republic. This would serve as a middle ground, which, quote, may support a due supremacy of the national authorities and not exclude the local authorities. William Patterson's New Jersey plan defended state power more than Madison's compound republic, with a unicameral legislature and state equality. However, the Great Compromise's bicameralism ultimately supported Madison's partly federal, partly national plan.
Madison also proposed a federal veto on state laws, writing, "Experience has evinced a constant tendency in the states to encroach on the federal authority," saying that a veto would uphold the supremacy clause while avoiding violent coercion to enforce it. Skeptics like Elbert Jerry and John Dickinson believe that a federal negative could be abused for political gain, and Thomas Jefferson wrote that a negative would, quote, attempt to mend a small hole by covering the whole garment. Ultimately, the delegates voted against the proposal, but the issue remained.
Without a federal negative, debates about conflicting federal and local laws arose for the Alien and Sedition Acts and in John C. Calhoun's infamous arguments for secession. In recent years, states continue to contradict federal laws for issues such as marijuana, gun rights, abortion, immigration, and school choice.
Issues of representation today prove just as contentious as in 1787, though today they are complicated by questions of race and popular enfranchisement. While the 14th and 15th Amendment attempt to recognize Black Americans' right to vote, later legislation such as the Voting Rights Act was necessary to actually vindicate that right. The United States should amend the Constitution to include the Voting Rights Act.
America's territories present issues of both federalism and representation. While Article 4, Section 3 of the Constitution outlines the process by which Congress can make territories states, granting them representation, American citizens who live in territories have no voting power at the national level. Instead, each territory has one non-voting representative, or two in the case of Puerto Rico. The Constitution should be amended to address this lack of representation by giving each territory's government the power to enact a binding referendum on statehood if the territory has a population at least equivalent to the smallest state. Even before becoming a state, territories should have full representation in the House and have no representation in the Senate.
As for federalism, the US government can impose their will on territories. For example, Puerto Rico only gained self-governance in 1952. The Constitution should be amended to ensure the self-governance of territories by extending the mandate that all states have Republican forms of government in Article 4, Section 4, as well as extending the 10th Amendment to territories. Thank you, and we are now ready for your questions.
Thank you very much for your opening statement. I'd like to start by asking you to tell us about the founders' debates about the presidency and the executive power.
Well, looking at the founders' debates of the presidency, the founders wanted to focus on a separation of powers. And although the founders did agree on the creation of an executive, as they had seen the faults of not having an executive in the Articles Congress, where the national legislature struggled to enforce any laws. And so the founders focused on making sure the executive was separate from the legislature, for example, by having the election be through the Electoral College instead of being by the legislature, while also making sure the executive had checks on the legislature.
The framers were also, well, anti-federalists were also concerned about the executive becoming a tyrannical military executive. Past history from prior to the convention and prior to the American Republic showed that figures such as Cromwell, executive overpowered with military powers could lead to a tyrannical executive. And that's why, although they gave the executive commander-in-chiefship power as outlined in Article 2, Section 2, they also kind of separated that power just a bit by giving Congress the power to declare war in Article 1, Section 8. So I think the military aspect with the executive was a key point of discussion.
Yeah, let me follow up on that with this. There's an argument in the literature, in political science, and in history that by the 21st century, we're living in the cult of the presidency. So where we are today, and historians are trying to be big picture thinkers and trying to be big picture thinkers, were the anti-federalists right? Have we descended into government by president and a cult of the presidency? Or does the Constitution still have some relevance on that institution? Help me out.
Well, the framers, especially Madison, intended for the legislative branch to be the most powerful branch. That's why we see in Article 1, Section 7, and Section 8 and 9, they have the most explicit powers as well as the most restrictions given to them. They are the force of the nation, so to speak. But we see, I agree with your proposal that in recent decades, the president has been accumulating power, and a lot of that is attributed to the partisan politics. The congressional bodies, when they are in agreement with the president as far as parties go, give up their own powers, and they give up the powers such as declaring war. We saw that in Vietnam with the passage of the 1964 Tet Initiative, or Tet, we saw that they
Tonkin Gulf Resolution.
Tonkin Gulf Resolution. Thank you so much. They expressly sort of avoided the issue of congressional powers to declare war and allow the president to go ahead and enter into Vietnam, which was not an official war, but it essentially was. And we see the accumulation of especially military powers under the executive.
I would also, sorry.
No, go ahead.
I would also add that with the increase of technology, the president has become a figurehead that the people can look to. This has led to the president leading the party as well as attempting to lead the country in an emotional manner. And we see these after tragedies such as 9/11, where the country looked to George Bush to lead the country. And we saw a rally around the flag effect with his approval rating skyrocketing. And so with the advent of TV and a president being able to appear on TV and directly reach out to the people of the nation, I think the people have begun to connect with the president much more than they connect with their representative.
Just to quickly add on to that, we have seen some pushback from Congress. We can see the War Powers Act or the AUMF as examples of Congress kind of checking the president's military powers. As my partner elaborated on technology, referencing Hamilton in Federalist 70, talking about vigor and energy in the executive, we've seen many technologies such as nukes or drone strikes that require quick decisions from the president. So I think that does mirror some of the debate, but we have seen Congress kind of, in some forms such as the War Powers Act or the AMF, kind of push back a little bit.
So I want to talk to you about your suggestion of the proposed amendment regarding territories. And specifically what I'd like to ask you If I were a resident of Puerto Rico, I would feel that your proposed amendment is an effort to quash my belief that we ought to be a state. How does what you proposed not seem to say to the people of Puerto Rico, no, don't push for state. We gave you, y'all go ahead and run your own government.
Well, looking at our proposed amendment for the territory, we do include that that the legislature of Puerto Rico can enact a binding referendum on statehood. And so our amendment, the goal of our amendment was to give territories the option to become states without taking away their right of self-determination. So they would have, through a referendum, the right to determine whether they would like to be a state or remain a territory.
So by proposing something to give me powers that we already have, you are thinking of Guam and Virgin Islands and all these other people and saying, and by the way, Puerto Rico, we recognize what you're already doing?
Well, currently, when Puerto Rico does have a referendum on statehood, the United States Congress and the United States in general has no binding resolution to have to make Puerto Rico a state. And on our referendum, Puerto Rico, through a referendum, would have the ability to make itself a state without need of approval from the federal government.
Got it. Okay. All right. Thank you.
Neither the Constitution nor the Bill of Rights provides for a right to vote. Do you think that that was an issue that was bypassed or pushed to one side by the founders during the Constitutional Convention?
Part of the reason why there was no explicit right to vote provided in the Constitution itself is because that was sort of, that power was relegated to the states themselves. And we see this because in many northern states, free blacks had the right to vote. And in many southern states, obviously slavery was an issue that would prohibit that sort of behavior. But we propose in our paper that we should have the Voting Rights Amendment added to the Voting Rights Act added as an amendment to the Constitution, which would provide a positive right to vote for Americans.
I think at the time, the reason why they didn't include a right to vote was because of the state legislators. You had states such as South Carolina that had pretty strict property requirements, but even if you look at a state such as Pennsylvania, which abolished property requirements for white men to vote, it was a unicameral legislature, and it wasn't the best model. It was very passion driven. And so given the fact of the environment of the state legislatures, most state legislatures had property requirements. I think that's why they didn't include the right to vote. That was a major reason.
I would also add that many of the framers simply did not believe in the common man's ability to vote. Elbridge Gerry in particular thought that the common man's ability to vote in Massachusetts had led to incredibly corrupt and ineffective legislatures being elected. And of course, at the time, the framers did not even consider having a large proportions of the population, such as Black people or Native Americans or women, having the right to vote at all, much less white men without property, or even white men without property. And so we see that, and then we had partially seen that as well from the relationship between creditors and debtors in states such as Rhode Island, where debtors had voted in representatives that had inflated the currency and harmed the economy of the state.
But our ideals of the right to vote through the passage of the 15th, the 19th, and the 26th Amendment have expanded so much. And I do agree that we need to have this positive right to vote and that it is an inherent American right.
So Jackson got it wrong. It was Andrew Jackson's idea of political democracy where Bubba and Skeeter can vote without property. It undermines and destroyed the republic that the founders were trying to establish. Is that what I'm hearing?
Well, we think that expanded suffrage has been has been good for American democracy. And we've seen that over time with the passage, as my colleague mentioned, the 15th Amendment, the 19th Amendment, the 24th and the 26th Amendment, and the Voting Rights Act, as suffrage has expanded, the United States has not collapsed as a result. In fact, you can argue the nation has only grown more powerful, more prosperous after these amendments has passed. And so I would say that the expansion of suffrage is not a hindrance to the nation, but a good thing. And that's why we want to have the Voting Rights Act in the Constitution.
In a time in which our country is incredibly polarized, with a huge number of states trying to restrict right to vote, finding ways to change that, how do you envision ever getting your amendment passed?
I view our amendment not as a practical amendment for right now, but a necessary and right amendment. Our nation is formed under the presumption that all men are created equal, and that has changed over the years. And obviously, Madison's belief of all men and my belief of all men would be very different. But I agree that court cases such as Shelby County v. Holder, which have restricted the right to vote, are abhorrent.
I would also add that I think there is some practicability. The Voting Rights Act is one of the most important legislation ever passed by Congress and is extraordinarily popular with the American public. And so to try and resist the Voting Rights Act, I think would to some degree be political suicide.
And it's not, I would just add quickly that, sorry.
Your time is up. Thank you very much. Let's show our appreciation for the team.
Well done.
I think you did a very nice job. I like your discussion of the issues that were resolved at the Constitutional Convention, including slavery, the issue of federal versus state power, and the federal veto, the issue of federal veto of state laws. I like your answer to my question about presidential power. That was good. With regard to your proposed amendments to the Constitution, I was wondering two things about your proposal for the Voting Rights Act. Number one is since it's a law right now, what would be gained by making it an amendment? And number two, I didn't hear you mention the Supreme Court's decision in Shelby County v. Holder, which cut back on the extent of the Voting Rights Act. And so if there was going to be a Voting Rights Act as an amendment, what is your view about the pre-clearance provisions that were invalidated in the Shelby case? I did like very much your answer to the question about voting, whether that was something that was overlooked, and especially your reference to all of the voting amendments, because if you look at the 27 amendments to the Constitution, many of them have involved the issue of voting. And so if we look at it from a historical perspective, voting could be seen certainly as one issue that was overlooked and that has changed as a result of the amendment process. So I think you did a really nice job, and you should be very pleased with your presentation this morning.
Yeah, I want to tag on what the judge said. I think it was a nice presentation. A couple of issues. First, look, I know we're in the finals. Slow down, folks. You've got a lot of information. You were downhill with no brakes at a couple of times, so that you clearly have a lot to say. You clearly know what you want to say, and you got a good handle on it. And it's just sometimes an avalanche. So it's okay. Breathe every now and then. You talked around Federalist 39 with the compound republics, but you never told me about Federalist 39 itself, where we're partly federal and partly local and all the rest of that. So I always like, my two favorite words are be specific. I always like a little more specifics there. Because I work in the era of Lincoln, worry about the 15th Amendment. It does not grant the vote. It says that no state shall deny the vote on account of race, color, or previous condition of servitude. It's a restriction on states, not a positive grant of the vote. Now, completely normal for people to lump it that way. I still think you did a really nice job. Nice going, folks.
So again, we've met each other before. So I want to start by congratulating. That I think is the important thing for me to start with. Secondly, and I want to just share something with you, because I watched some faces during the comments of my colleagues. If you think we weren't listening, we were. I heard Shelby. I mean, I watched your faces during the critique, and you're thinking, wait a minute, did they hear me? I mean, just so that you know, we were listening. Okay, so don't let that go. I was really very pleased with the way you incorporated bullet points into your discussion all the way through. This is where the weakness is. this is what happened. This was the consequence. We didn't have to wait as though you handled part one, part two. No, that you incorporated. And that to me was a considerable strength of the presentation that I heard. I would love to spend a little time chatting about a couple of the other issues. The self-government by the territories one is the reason I started with my question about that, is because that's one of the possibilities that, you know, if you were to say, are we going to ever get that ratified? I would say Mr. and Mrs. Idaho and Mr. and Mrs. Montana couldn't care less. And so I don't know that we would ever get that done. But one of the things that I really love about young people, especially young people who've taken the time to study the Constitution, is that you all have an optimism that I hope in one part of my life I had. It got old too, so I don't know. Anyway, you all really, it was a pleasure once again to hear from you. You are to be congratulated. I'm glad your teacher showed up again, because I want you to please recognize in a difficult year, he worked hard just like you all did. Good luck to you.
Thank you. And
Good luck. Thank you.
All right,
Your weekend
everyone.
with us,
At
Judge.
this time, I'm going to open the judge's room.
Okay, breathe, it's okay.
thank you for judging us today.
No problem.